Good evening. This is a meeting of the Athens Board of Zoning Appeals. The time is 7 p.m. and the date is March 12, 2013. At this time, I will call the meeting to order. The board consists of 5 members and 2 alternates, the alternates taking full part in the discussions and becoming voting members in the absence of a member or when a member abstains for conflict of interest. Present tonight are Greg Lavelle, John Golsey, Kay Towsley, Mr. Raby, both of whom are alternates but who will take full part in the procedures tonight. Also present are Zoning Administrator John Paskey and Secretary Paul Eschenbacher. The board operates under the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall then be closed and the board will deliberate and render a decision. According to Athens City Code, Section 230703B, the board has power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to the City Code, Section 230910C, variances from the code shall not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions has been supported. The first one is practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of the regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Number 2, exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Number 3, preservation of equal property rights. Literal interpretation of the regulations would deprive the appellant of rights commonly enjoyed by others in the same zone in the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that's denied to other properties in the same zone and the same vicinity. Number 4, minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. 5, absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purposes of the zoning code or the public interest. The last one is not of a general nature. The condition or situation of the specific piece of property or the intended use of the property for which the variance is sought, one or the other, or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by a decision of the board may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petitions must be filed in 30 days after the mailing of the decision of the board to the applicant. Tonight, there are 2 cases on the agenda. The first one is the property at 46 and a half Morris Avenue. The case is 1302V. The second case tonight involves the property at 68 North Court Street. The case is 1303V. The board is required to take testimony under oath. So, would anyone who wishes to speak tonight concerning any item on the agenda please stand? Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So, our first case tonight is, as I said, 46 and a half Morris Avenue. It's in the R1 zone. And the applicant here is requesting variances from ACC 230401A to allow an existing non-conforming use. It's non-conforming because it has two principal structures on the lot, and also one building, a private, I'm sorry, I'm reading this incorrectly. I'm starting again. The appellant is requesting variances from ACC 230401A to allow an existing non-conforming use, that is to say, two principal structures on the lot with one building a private home and the other a rental unit, to change to one owner-occupied rooming house and one rental unit, where one principal structure rental unit is the maximum allowed. And from section ACC 230401B5 to allow an owner-occupied rooming house with three renters, where only two renters by a resident owner is the maximum allowed. Okay, so Mr. Eschenbacher.
Okay, just to clarify, the private home is at 146 and the garage apartment is 146 and a half.
Mm-hmm.
Obviously, in an R1 zone, you can only have one rental unit and one principal structure, but the rental permit for 146 and a half, it is a legal non-conforming use, as it is the second unit. As you notice, there was no request or need for a variance for parking. If this goes through, if the variance should be approved, then the property would need a total of 7 parking spaces. That is 2 for 146 and a half, because that's the minimum that's required for any rental unit. And then for 146, the main house, they would need beginning 2 spaces and then 1 additional space for every renter that they want. So they're asking for 4 in that house, including the owner, and so they would need 5 spaces. Now, if you visited the property, you'll see that the driveway in front is big enough for 3. And then there's a grass space and then a garage underneath the apartment. If they were to fill in that grass space, that would provide an additional 2 spaces. If the garage was usable, that would provide a 3rd space there for a grand total of 6 in that whole driveway space. There's also a parking space off the alley adjacent to the garage apartment. Also, if they would decide to pave all that in, it would still be under the maximum lot coverage percentage. We figured it out, and even if they filled in the rest of the driveway to the garage, the maximum lot coverage would be approximately 58%, and the maximum is 60. So if you have any questions.
Okay. Does anybody have questions for Mr. Eschenbacher? Okay. Will the appellant or representative come to where you can be heard? Where you are is fine. Tell us your name and address, and tell us your case.
I'm Christina Delisandri. This is my son, Adam Delisandri, and we live at 146 and 146 and a half Morris Avenue. And what was the... I don't hear very well.
We'd like for you to tell us what this appeal is all about.
Sure. Right now, I live in the garage apartment, and my son lives in the main house, and he has a vision impairment. And one thing, we don't need a parking space for him because he's not able to drive a car. And it seemed like a good arrangement for us because he can have some independence, be in the house with his friends, and so we wanted to be able to rent out up to 3 rooms for his friends, so he's safer in the house because of his vision impairment, and then to have a social life too, because of those issues. So that's basically it.
Okay.
I just wanted him to be with other people, so he's safer.
Okay. Well, you do realize from what you've been told by the code office, I'm sure, is that he could easily and legally have 2 renters in
We
this zone.
we didn't realize that until we read today what was on your website, because when our original request was denied, the person wrote, refused legal, non-conforming, 2 primary structures on 1 lot, front unit can only be occupied by owner. When we read that, we thought, oh no, we can't have anyone in there with him.
Well,
It's a big house, it's 5 bedrooms, so I think maybe we misunderstood this. So that's when we started to ask for approval for the owner-occupied rooming house.
Well, I think maybe you were confused because there are 2 things happening in this zone. If you want to rent and you live in the house, there are only allowed to be 3 unrelated people in such a house, even if it has 20 bedrooms. So that's the first thing. And then the other thing is that the property is now non-conforming because it has 2 livable structures on the property where only 1 is typically allowed. But a lot of properties in Athens are grandfathered in because they were existing when the zoning code went in or when it changed. So those 2 things might have confused you, but he can easily
Well,
have 2 people.
when we
renting.
read this, we thought, that's it, nobody can stay with him. So that's when I started the narratives and the appeal and everything.
Okay.
If we had known that we could even have 2 or 3,
2.
are you saying?
3 unrelated people
So that would be my son and 2 friends.
and 2 friends. So then you don't need a variance.
That's helpful. It would be nice for him to,
They don't need a variance for that section, they would still
Right.
need the variance for having 2 rental units on one property.
Well, but they don't need a variance for that because they've already, that's already grandfathered in.
No, only,
Oh, I see what you're saying.
Because it was a
Grandfathered-
private home before,
2
and they want to
rentals.
make it...
I see.
yeah.
Okay. So, yes, that's true. Okay, you're really asking for 2 separate things. And the other thing that the code says, if there is a non-conforming property, even if it is a legal one, which yours is because it was grandfathered in, the non-conforming properties are supposed to eventually come into conformance, and making them more non-conforming is really not what we're hoping for. And in this case, you would be becoming more non-conforming by having 2 rentals on the property and more people than would normally be allowed.
well, I'm, like I said, concerned with his safety, and I'm trying to get him set up when I'm gone.
Sure. Okay, so you want us to go ahead and talk about this and vote on the 3 people and the 2 rentals?
I'd appreciate it.
Okay,
And,
all right, here we are.
Do
We
you,
can
do you want to
certainly
say
do that.
anything? at all?
Do you all have questions?
Can he speak too?
Okay, sure.
One thing about having 3 people around too would be if one of them's at work or something and I break a glass because I'm kind of clumsy and sometimes, and it'd be nice to know that somebody would probably be around to help me clean it up before I before I hurt myself doing that or something. But I don't know, it's just mostly for the safety reason, having somebody that I trust around to do that, and for that kind of limited assistance when I'm in a position where it's difficult to fix what I've done myself because of the vision.
Okay.
That's about it, really.
Okay. Is there anyone here who would like to speak in support of these variances? We don't have a very big crowd tonight. Anyone who wants to speak in general comment? Yes. Please, just tell us your name and address and tell us what you're thinking here.
My name is Tim Myers. I live at 134 Morris Avenue, next door to the Delisandris, despite the
difference in the numbers. It's there right next door. I guess I'm here mostly when we got the notice of the meeting today, just to find out what was going on, and I've learned more just in the few minutes that I've been here about the nature of their request and some of the things that you all are looking at. I guess my concern, the D'Alessandris have been very good neighbors. They've put a lot of money and effort into improving the property, and the tenants that they have been very cordial and good neighbors. And so there are no issues from our standpoint in that regard. I guess our concerns mostly are around parking, number of vehicles, and also about what happens if you are to grant a variance. What happens if they would decide to sell the property?
The variance goes with the property. The variance doesn't really go to the owner, it goes to the property.
Okay, that's a concern of
So
ours
it
in
would
the
be-
sense that
and it would be
we have a
to
nice
rent for-
living arrangement right now, but if we were to have other renters in a situation with that variance, that would not be as cordial, it would not be as concerned about upkeep and about the noise and those kinds of things, so we'd have a concern. In terms of parking, it has not been an issue. Parking on our street is more of an issue when the fests take place, because things fill up a good deal. But I would caution the gentleman here from the enforcement office that you're talking about one driveway, and I think it's probably inadequate to suggest that all those cars are going to be moving back and forth and in and out and not have some on-street parking issues. Still, that has not been a large issue. I understand that the Near East Side Neighborhood Association has expressed some concerns about this with respect to R1 zoning, and that, of course, is something that we support as well, because we were among the people that supported the efforts that you and others have made to establish R1 zoning and support that on the east side. I think I'm not sure that this particular variance request does anything to the detriment of that, but again, I worry what happens when new owners take charge of the property, about what might happen once the variance is granted. If it follows the property, that could be problematic. So
Yes.
those are my only concerns.
Thank you.
Can I respond to that a little?
Yes, you may.
Because the very last paragraph of my narrative, and I think you're saying that this isn't possible, is to please consider issuing the variance for only so long as Adam D'Alessandri resides in the house. I think it's a very specific thing just for Adam in a situation. Yeah, if it's possible just to grant it for him, that would be fine with us. We're not trying to set up a business here.
No,
And like
we
I said, he'll
understand.
never drive, so that's one less car.
Yes.
Also, I'd like to add that John and I have discussed it, and we believe that the board is within their rights, if they choose to go forward with the variance, to have a condition that the variance last only as long as with the current ownership, and that the variance would die once the place was sold off. Or you could even make it more specific that not only does it last only with the current ownership, but with the current setup, where Mr. D'Alessandri lives in 146 and Ms. D'Alessandri lives in 146 and a half. That way, if you're concerned that at some point, if Mr. D'Alessandri should move out and then she would still be there, that she would have the right to rent out the main house. So again, I think John and I, what we're saying is, if you want to, if you decide, you're allowed to put that condition on there that this variance only goes with the current ownership, if you want to.
Did you all talk about a conditional use permit? Is that an appropriate?
I don't think this technically falls under that category.
Not because it's a rental. I don't think it would.
Yeah, because of the specifics of it being a rental property. The reason why I think such a condition would be allowed is the D'Alessandris are basing their need for a variance on the condition of the D'Alessandris rather than the condition of the property.
Exactly.
So, if you should decide to. or not.
And the other option, if they want to do it on the condition of the property, which we've suggested, is the variance, there wouldn't be a variance, in essence, we transfer the rental permit to the house. That would be a 3-person rental, and then the garage become the owner-occupied unit. Wouldn't need to have the variance per se, or a condition on it, but it could never become 2 rentals on one property if we would switch it around that way. I just didn't know if that was something you were interested in.
I would not like to have the rental permit transferred to the house. And one thing down the line is that I'm going to pass away one of these days, and I'm trying to get a income for my son from it at the garage apartment.
You'd have more income from the rental of the house.
Hmm?
I think she would have more rental income from the house and the apartment as it is now as the primary residence. Is that correct? There's more potential there financially?
Well, we're not really looking at income. We're looking more for his safety, and, I mean, sure, it's nice to be able to do it. But, like I said, we panicked when we read this, that front unit can only be occupied by owner. I guess we didn't understand what that meant. But if we pursued it this far, we'd like to be able, it's got 5 bedrooms, so we'd like to be able to have at least 3 friends in there.
Okay.
So I have
That's
a
to
question.
say.
So the substitution that you're suggesting could be made?
Well, it wouldn't technically be a substitution. It would be
Switch.
switching. Now, the problem with, I mean, right now, 146 is the rental, 146 and a half is the rental, 146 is the private home. If you'd switch it, so 146 is the rental and 146 is the private home. And since Ms. Delisandri lives in 146 and a half and is co-owner of the property, that would be allowed. Of course, he could only have 2 people in there, it being an R1 owner-occupied rooming house. And the problem would be in the future is if they would sell the property, then the next person, since it would be a change, unless the next person wanted to live in the garage apartment and rent out the main house, which I think would be less likely, but, you know, that would be up to the Delisandris, and that would be their problem in selling the property if they would want to in the future.
Right, and if she was no longer there,
Right.
he would not be able to rent out the garage as a rental if we switched it the other way. He would have to move into it and rent out the house, or it couldn't be used. It's one way or the other.
I guess one of my concerns is things that we've encountered before, maybe not very recently, but certainly in the past, when people came to town and looked at houses that they wanted to rent to their sons, daughters, or people, and somehow didn't get the information that only 3 unrelated people were allowed, or that some other condition was attached to the house that the rental agents didn't know about, and therefore they buy this property and then they're furious because they're not allowed to do what they thought, because somehow the records are not keeping up with the house and getting to the people who need that information. So I think it's a problematic situation.
Well, a little bit of what realtors tell them,
Okay.
too.
Yes, I know. Okay, the next thing, did you go ahead and say what you were about to say?
Oh, just that we really want the permit to stay with the garage apartment.
Okay.
With 146 and a half, whatever you
Okay.
decide.
Well, the next thing, yes.
I'm sorry, would it be possible to switch the permit back to the garage?
It still is. We never have switched it.
Well, I know. I'm saying
In the future.
hypothetically, like if we were able to do that, to have it switched back to the garage after I don't know if I had started a family and was living in the main house and wanted to rent the garage apartment out later in life to create
That's,
some extra
these
income.
men in front of you need to answer that.
Where he's at right now. Technically, that's where it's at now.
Yeah.
So,
I don't see why, just because you've done it once, you couldn't reverse it in the future if you or somebody else had the property. The main thing is we'd like to prevent there being 2 rentals on the property now and later, And I, for one, would like to maintain the idea that we have 3 unrelated people in a house. And perhaps that's because I'm one of the people who was involved in starting the East Side Neighborhood Association, and we have a letter from them. And my next step would be to say, is there anybody who wishes to speak in opposition to this variance? And here is a letter from the East Side Neighborhood Association dated yesterday. Dear BZA members, we note that you have on your agenda for March 12, Case 1302V, which concerns a property at 146 Morris Avenue in the near East Side neighborhood. This area is zoned R1. This lot already contains 2 principal structures on one lot, and the proposal, if allowed, would produce an even higher level of occupancy with the concomitant issues of traffic and parking. While not wishing to deprive the owners of the full benefit of their property, they should have known when they purchased the property in 2008 that it is in an R zone and that it was already a non-conforming but grandfathered lot. We think that further increase in the occupancy of this lot is against the spirit of the move many years ago to make almost all of the near East Side neighborhood an R1 zone. Thank you for your careful consideration of the matter. Sincerely, members of the Executive Committee of the Near East Side Neighborhood Association, Edward Baum, Alan Boyd, Sue Boyd, Christine Fall, David Ingram, and Ben Lockman. Yes.
Also, Mr. Baum sent a second email, which I think got you
Maybe
guys.
I didn't get
With your
that.
permission, I'd like to read that.
Yes,
aloud.
please.
Okay. Dear members of the Athens City Board of Zoning Appeals, it had been my intention to be at the Tuesday evening meeting of the board, but I have to be in Columbus during the day, and I'm not sure if I can get back in time. Please find attached a letter from the Executive Committee, which you just read, of the Near East Side Neighborhood Association objecting to the granting of a variance to the property at 146 and a half Morris Avenue. In addition to the comments noted in the letter, there is another objection, the substitution for a more objectionable nonconforming use. As you are all aware, the Athens City Code provides, under ACC 230502, no existing building or premises or the use thereof not permitted by the zoning code in the zone in which the building or premise is located, except when required to do so by law or order, shall be enlarged, extended, reconstructed, substituted, or altered unless changed to a use permitted in the zone in which the building or premises is located, and except as follows. A, substitution. When authorized by the BZA, the substitution for a non-conforming use of another not more objectionable non-conforming use may be made. However, in an R zone, no change shall be authorized to any use that is not a permitted or conditionally permitted use in any R zone. In a B zone, no change shall be authorized in any use that is not permitted or conditionally permitted in any B zone. Thank you for your consideration of our letter and the comments above. Sincerely, Edward Baum.
Okay. Now, do you want to put that in layperson's language and tell us?
I think he wanted to say that in case the board might consider, instead of a variance, a substitution. I think he wanted to emphasize that a substitution for a non-conforming use for another not more objectionable non-conforming use. It's my opinion what Mr. Baum was trying to say is that if you would substitute what the Delisandres want, that would indeed be a more objectionable non-conforming use, in his opinion.
And I would agree with that. But others might not. Any other questions before we proceed in some fashion? Questions from you? Okay, are you ready to, something else you all would like to tell us? Say again? Okay, then we're going to go through the findings and then we'll vote and see what happens. Okay.
Motion.
Yes, a motion, thank you. Easy for me to forget.
Okay, I'll make one. I move to grant a variance to the property at 146 and 146 and a half Morris Avenue from ACC 230401A to allow an existing non-conforming use, which is 2 principal structures on one lot with one building a private home and the other a rental unit, to change to 1 owner-occupied rooming house and 1 rental unit, where 1 principal structure/rental unit is the maximum allowed. And from ACC 230401B5 to allow an owner-occupied rooming house with 3 renters where 2 renters by resident owner is the maximum allowed.
Second.
Okay, thank you. Okay, is this the motion you want? Straight
I
on, no
think so.
conditions? Okay.
Yes, yeah, no conditions.
Okay. The first thing we need to consider is practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of the regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes.
There is no practical difficulty with respect to the property.
Correct.
And it is personal, but that's not what we are considering.
Yes, I think that's right.
Okay. Exceptional circumstances. They are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
Again, I don't think that the property itself
As in-
results in a hardship. It's not property.
Right, and I don't think in this case the use, it will still be used as rental and/or owner-occupied, so I don't see anything extraordinary about the use. Is that
Right.
right? Do you agree with that?
I do.
Okay. Preservation of equal property rights. A literal interpretation of the regulations would deprive the appellant of rights commonly enjoyed by others in the same zone in the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone in the same vicinity.
Well, this property, because it's grandfathered already, is enjoying additional privileges for having 2 property on the same. So even this was going to increase that. So they already are getting more rights than the others in the same vicinity.
Okay, and you're saying this would simply increase that?
Increase that, yeah.
Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property.
Well, the additional person just makes it not minimum.
Right, and 2 rentals
Yeah.
make it not minimal. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purposes of the zoning code or the public interest.
Not right now, but maybe in the future.
Okay. Okay, not of a general nature. The condition or situation of the specific piece of property or the intended use of the property for which the variance is sought is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such a condition. And I think that's definitely a no in this case. It's not of a general nature. You have a very specific personal need for this rather than something.
I'm
that
sorry,
is
I can
very-
barely hear you.
Okay, I'm sorry.
It
My
really
voice is
doesn't.
hard to hear, I'm sorry. Are you, anything else you want to say? A vote? Okay, we'll start with you, Ms. Kathy.
No.
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 And I also regretfully vote no. And I hope you do understand that you will be allowed to have people in the house with your son and you, but maybe not 3 of them. Yes.
Just to fill you in and inform you, I think our code does allow for some medical conditions and options and such. And Mr. Alessandro, if you'd like to come in and speak with me, we talked about a number of them sitting here, some different things, but because of the Near East Association's letter, and they're not being present, I don't think we could have changed the actual ordinance tonight without it being advertised. But I'd be more than happy to sit down and discuss some options with you, and then we can kind of go from there. So what I'm saying is it may be
Okay.
back
Okay.
for some different.
That's perfectly allowable?
That would be great.
Okay. Yes. So,
Okay.
yes, go in and speak to Mr.
I
Peskin.
really don't know what he would suggest other than
We'll
having
talk.
extra people around.
Well, come on in and we'll go from there.
Okay. Okay, thank you for doing that, John. The next case that we have tonight is somewhere around here. This is the case at 68 North Court Street. The applicant is requesting a variance from ACC 2310, Table A, Schedule of Bulk Controls, to allow a change of use in a building space from commercial to residential. The residential use will be one 5-bedroom apartment in a building with side setbacks of 0 feet, where 10 feet on one side and a total of 15 feet on both sides are the required minimums, and a rear setback of 4 feet, where 10 feet is the required minimum. Okay. Mr. Eschenbacher.
It's pretty much self-explanatory. They're just changing an office to an apartment. They have the legal parking within the required distance, the right amount. The peculiarity about this is, even though most people consider this the uptown area, it's B3 rather than B2D. In B2D, there are no setbacks, rear or side setbacks. However, a block down here, they are required to have minimum side and rear yard setbacks.
But they don't.
So if you have any questions for us.
Is the fact that it's changing from an office to a resident?
It's a reason we're, change of use. That's the
So
reason.
they wouldn't be here if they wanted the renovation for office to office?
Correct,
That's right.
Even though the use is allowed?
correct.
Yeah.
Okay.
And I do have a question for Mr. Valentour, but I guess I'll just wait for him.
And I'd just like to clarify, at Planning Commission meeting, and I believe one other location, I was telling people that this was the apartment above the Public Defender's office, and I'm incorrect in that. It's actually above the Import House, and Stevens.
Okay.
No, Stevens is there too. So I was in the wrong
No,
building.
no, it's the import house.
Import House. It's above the Import
Michael Wu's
House. So,
office.
in case anyone watched that.
Yes, okay, so the shoes are downstairs, and who's upstairs?
Mike LaRue has his offices.
Okay, Mike, okay. And so all the upstairs that's occupied is his territory?
No, half of it is.
Okay.
Half of it was rented. I can.
Okay, all right. Yes, come on up and tell us who you are and all those things.
Golly, new table here too, huh? John Valentour, RVC Architects. I'm representing Mike LaRue on this case tonight. And it is 68 North Court Street. It's the former Harris Building. I don't know if that's for the old
Yeah.
folks around here remember.
Be me.
The Import House takes up the entire first floor. Mike LaRue's rental offices take up half of the second floor.
Okay.
The other half of the second floor was or has been rented out as a commercial use, as a business. But it's been vacant for a couple of years now. And the intent is to put a 5-bedroom apartment on that second floor.
Let me stop you and ask you, has Mr. LaRue been searching hard for a business to go in there or
Yes.
rent it to a business?
The last resort here, because of the amount of money that it's going to cost to make this alteration.
Okay. Could I ask you a couple of things about the application?
Certainly.
I mean, your letter.
Yeah.
Okay. It says in the first paragraph, we're asking for relief on the project. The work involves half the second floor. The current space is vacant. The first floor and half of the second floor are currently occupied by businesses. This is required due to the change of use to an apartment. What is this? You mean the variance?
This variance is required.
All right, that's my first question. And on another page, you're talking about minimum variance. The request is the minimum required for reasonable use of the property. The existing space is vacant and, quote, not accessible.
Accessible.
What do you mean by that? You can't get into
It's not
it?
handicapped accessible. A lot of businesses require handicapped accessibility.
Oh, okay, for handicapped people, you mean?
Yeah.
Okay. All right,
I
thank
mean,
you.
a lot of businesses that
Yeah,
I work
okay.
for, or if it was a commercial a restaurant or something, requires accessibility.
Okay.
This is not an accessible location.
Okay, I just didn't get it, sorry. Okay, now, please go ahead.
Well, I'm going to continue along in the same line there, and I think that Mr. Paskey Paul also indicated, this is a principally permitted use for this zone. It's not that its apartments are not permitted to be on the second floor in the B3 zone. The reason we're here, the only reason, is because it is a B3 zone and it requires setbacks.
Right.
Now, this B3 zone does extend all the way down Stimson Avenue. However, the portion of it that's on Court Street really doesn't offer the opportunity to provide setbacks, side yard setbacks, because all these buildings are next to each other. I'm just going to go through my little finding thing here,
Okay.
just so I can tell you what my reasoning is here. Bulk controls requirements for this property cannot be met due to the existing conditions. The building is essentially already occupying the entire footprint of the property. The setbacks are not feasible because of this. And we will be providing parking, though, under the same ownership within 250 feet for the residential requirements.
Can you tell us where that will be?
Right behind it, almost.
I think that-
Do you have a map? I've got.
Okay, well, I saw all this, but I can't read that, so.
Actually, right behind the old inn for all the old people here, right behind where the bus station used to be.
Okay. All right. Where the restaurant now is?
That's correct. They own the property. They own that property, and there's parking back there for, I think, at least 20 cars.
Okay, you have
And-
to point to me. Oh, it's over here. Okay.
There are people parking there, and I'm sure, and I haven't done this, but I'm sure the code office will go through to make sure none of those parking spaces, or at least the ones that we intend to restrict for this project, are dedicated to some other business or residential activity that
So
is related.
How does this relate? What's this building right here in front of the parking lot?
That's the bus station.
It used to be Magic Video.
Oh, okay.
Right now, it's
Okay.
I think
Fashion Work?
Havar, and it's got the T-shirt shop.
Precision imprints.
And Precision Imprints.
Yeah,
Passion Works, Precision
Passion
Imprints.
Yeah, Passion Work.
it goes all the way back to Fern Street too.
Okay.
That the property they own. They've got over, I think I counted 19 parking spots back there right now that
Okay.
I calculated.
Okay.
Now, again, I haven't confirmed that those spaces are not designated. I think that would come through an evaluation from the code office to make sure that none of those spaces are committed.
Okay, and if
to
there
other
are, I assume the
activities.
variance is moot until we come back.
They'll be back for a variance for that if they
Okay.
Well, and I've got, right now, it doesn't really matter because it's break, but I took a picture and there's a lot of empty spots back there right now.
No one's in town right now.
Well, don't quote me, but when I did years back, Planning Commission recommended to the city council for this to be rezoned to B2D, this whole area. And I did a parking study of that whole area, and if my memory serves me correct, this will be okay. Because that space in itself would have been required to have 2 or 3 spaces of its own, if not more. So
I have lease agreements already written for that parking
Spaces.
area.
But just because somebody signs it doesn't mean it's there until the code office
That's
finds
right.
that it really is.
They need to be
there.
confirmed.
Okay, we will trust them to do that.
we will.
That the owners, though, have already committed to leasing the 5 spaces for the purpose of this project.
Wonder where those 5 people who used to rent the spaces are going to go.
It's not our concern.
Not our business.
Okay.
The East Side neighborhood.
Yes, probably so. Right in front of mine.
They'll have to find someplace else and pay more.
All right. Okay.
Going through the findings, the practical difficulty, the lot is located in a district of the city with a high density of structures. The intended use conforms with the zoning code. The nature of the lot creates a practical difficulty in conformance with the zoning code. And this would apply to any alterations or modifications that would be made onto this property, as long as if it was related to residential use. Exceptional circumstances, the setback issues are exceptional for this section of the B3 zone on Court Street. The zone extends along Carpenter and Stimson Avenue, where setbacks can be incorporated into the planning and development, which I've done on projects on Stimson Avenue. So that this portion of the B3 zone contains structures which cannot conform. So it's exceptional, in my opinion, into the B3 zone in which this property is located. The preservation of equal property rights. The proposed use of this property does not give this property any special privilege because residential is allowed on the second floor. The proposed use of the building is in conformance with the code. We're not asking for anything that's not in conformance with the Athens zoning code. A minimum variance. The request is the minimum required for reasonable use of the property. The existing space is vacant, and again, like we just indicated, Betty, it's not accessible. And so many times nowadays, if I'm doing a commercial building, I have to have accessibility. The proposed use is a reasonable solution or occupancy for this particular property. Absence of detriment. The granting of this variance will not be a detriment to the adjacent properties. Any of the properties in the immediate area have an equal opportunity to face similar issues related to bulk controls, right, in this part. So any property that comes in with any kind of request for change of use, I don't care what it is going to be faced with the same obstacles that brought us here tonight. And in terms of the absence of detriment to the neighborhood, the requirements that will be imposed upon this alteration will be, from the state of Ohio, will install a fire suppression system, not only for the apartment, for the entire building, which is it has a occupied basement and the first floor and the second floor. So all of it will become under that fire suppression system. And this will be a benefit to the occupants of this structure, which are not just related to the residential, but to the businesses and the mercantile, and to the adjacent structures, which are all wood frame, essentially. So what we're asking today is going to, it's going to upgrade the safety of this block down there. Not of a general nature. This portion of Court Street is a small section of the B3 zone. Most or a lot of the properties in the zone do not have the constraints created by the lot size and the density of the existing structures that this property is surrounded by. So therefore, it's not of a general nature. I mean, like I said, the B3 zone goes all the way down Carpenter and all the way down Stimson. And any projects we do down there conform. It's just this one and the ones on North Court have a little bit of a different nature.
Sounds like it. Any questions? Okay. Okay, thank you very much. Comments?
Well, I just wanted to say, if you're going to move on to the next portion, anybody want to speak for, make general comment or against?
Maybe
I
that
have
would
a
be
letter.
you. Okay, great.
This is to the Board of Zoning Appeals. I have no problem with the variance for this proposed improvement to our community in Reed of 68 North Court. It's signed Jack Stauffer, who is the owner of 72 North Court.
All right. And we don't have anyone else, unless you want to speak, Mr. Paskey, to object or support or
Oh, no.
speak in general comment.
Mr. Neutral.
Maybe he wants to speak again.
Okay. Questions to any of these people before we close the floor? Okay, let's close the floor. Let's get
I
a
just was
motion.
wondering, just for our
Yes.
own safety,
Okay.
if we could say that upon verification of the parking by the code office.
Sure, you
Just
can
to
put
the-
that on as a condition.
Not, yeah,
You can put it on as a condition. We trust them. right?
yeah, we know, but,
Okay,
That'll
put
have to
it
be
on
done when
anyway.
they do their
you know,
submittal
we are the
anyway.
board, so.
Okay, you can put a condition on anything you want to. So we need a motion, and John suggests it should be with a condition.
I move that we grant the appellant in case 13-03B, requesting a variance from Athens City Code 23.10, Table A, schedule of bulk controls to allow a change in the use of building space from commercial to residential use. 1, 5-bedroom apartment in a building with side setback of 0 feet or 10 feet on one side and a total of 15 feet on both sides of the required minimums, and a rear setback of 4 feet where 10 feet is the required minimum. Also with the condition that this property will meet the parking regulations for the number of bedrooms.
Second.
All right, let's go through the findings. Practical difficulty and undue hardship. Because of extraordinary circumstances, a literal enforcement will result in practical difficulty or undue hardship unnecessary to the achievement of public purposes.
Well, it's landlocked on that block, and there's no way to begin to obtain setback requirements.
Okay. And what's the exceptional circumstance?
B3. This particular piece of property is in B3, which is, the other ones are in B2.
Okay, and so it's in a zone that is in and of
Yeah,
itself
B3,
inconsistent.
that's- Yeah,
Right,
that's
okay, so it allows some properties to have setbacks and others not ever to have any, okay. Preservation of equal property rights, a literal interpretation would deprive the appellant of rights commonly enjoyed by others in the same zone.
True, we've already had properties on that street with second floor residential.
Okay, we certainly have. Is this a minimum variance to make a reasonable use of the property?
Yes.
Yeah.
Is there some detriment that will accrue to adjacent properties and impair the code?
No, in fact, it will increase the lack of detriment of no fire suppression system in an old wooden frame building.
Love your syntax, okay. Is this of a general nature that should be taken up to other properties in the zone?
No.
Well, sometimes you begin to wonder if this zone shouldn't be corrected and made more consistent internally, but we'll take
By
that
the
up
time it
later.
does, the
Okay.
street will all be residential anyway on the second floor. so.
Yes, I know. Okay, would you like to start the voting, Mr. Lavelle?
I vote yes.
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 Oh, yes.
And I will also vote yes. So you will have the variance. That's all of our cases. We have a little business. Has anybody read the minutes? Would you like to approve those? Or not?
I've read and approved the minutes.
Second for that?
Second?
Okay, we'll accept those. So unless there's other business, we're adjourned. Good night.